live on cause number DC 1916287, Wildwood Natural Corporation versus Shinchan Market. Counsel, make your appearance.
Good afternoon, Your Honor. Papul Chaudhary for plaintiffs Wildwood Natural Corporation and Chancho Park.
And good morning, Your Honor. This is Daniel Rowland on behalf of Kipina and Sihana Corporation defendants.
We're here on a motion for leave. Why don't we proceed?
Thank you, Your Honor. We'd like to use the share screen. Would that be possible, Your Honor?
Okay. Go ahead.
All right. On June 19th, in this case, fact discovery closed. And that's a very important date as I continue on with my argument. This fact discovery in this case closed on June 19th. Now, on October 13th, the defendants filed a partial motion for summary judgment. And what I've pulled up here, this is page 12 from the defendant's partial motion for summary judgment. And you'll see paragraph 21. It reads, the affidavit of Myung-Ho Lee is attached hereto as Exhibit J and is incorporated herein by reference. Myung-Ho Lee's affidavit shows that Mr. Park was being wholly untruthful when he fabricated the supposed witnessing of Mr. Na allegedly signing the forged notes. And what I've also got here is page 25 of defendant's motion. And you'll see here that under the heading, every individual that plaintiff Mr. Park states witnessed the alleged signing of the forged notes directly contradicts Mr. Park's fabrication. And under 74, which is to contradict what is said in 73, they point out again that Mr. Myung-Ho Lee has submitted an affidavit unequivocally stating the opposite. And then they go on to state what he says, which is he says that he was never at a meeting involving promissory notes. He never witnessed Mr. Na signing the promissory notes, and he has no knowledge. And I'm going to share one more document with you. This is Exhibit J to defendant's partial motion for summary judgment. It is this affidavit of Myung-Ho Lee that is referenced in the motion for summary judgment. And what you'll see, we've highlighted here the date. It was executed on July 16th, 2020. That's about 1 month after the close of the fact discovery deadline. Well, really, this affidavit here is using evidence that was obtained after fact discovery and then was included in the motion for summary judgment. By the way, we never saw this affidavit until the October motion for summary judgment. So really, this affidavit and everything that every argument.
I get it. Mr. Rowland.
Yes, Your Honor. In terms of explaining, I don't think we're here for a motion to strike an affidavit. I think we're here to reopen discovery.
No, that's
so
not
that
correct,
they're asking to take a deposition. And I think that's what they're here is. They're asking for a motion to leave to reopen discovery.
That's not
to
correct.
Take the deposition of this individual, even if it's just a little bit. And this is a witness that back in their interrogatories, they identified as a fact witness well before fact discovery closed. This is a witness who, when we took their deposition before fact discovery closed, said that he was a fact witness to this transaction. I don't know why they would.
Has his deposition already been taken?
No,
that's what we're here to seek leave to take.
Yeah,
you just said when his deposition was taken. Whoa! When I'm talking, don't interrupt me, please. When Mr. Rowland, did you say that his deposition had already been taken?
No, Your Honor, that was a miscommunication on our part. During the deposition of Plaintiff Chancho Park, Mr. Park stated, and this is what he said was, we asked Mr. Park if anyone saw, because we thought these notes were forgeries, did anyone see our client, Mr. Na, sign it? And he says, yes, Myung-Ho Lee saw it. And then in their interrogatory responses, they also listed Myung-Ho Lee as a fact witness to these transactions. So we went off and we spoke with Mr. Lee, and we don't understand why they did not do so, because we've asked the court and plaintiffs to continue fact discovery. and they have vehemently said we won't do it. And they showed us, actually, they pointed us to your hearing in which they said, look, the judge says fact discovery is closed. So we haven't been able to do any fact discovery of any means. And we don't understand why they would put this fact witness in their, basically in their interrogatories and bring him up as a witness to this and then not do anything about it. And then when we go off and we do our diligently pursue discovery and we find out that he directly contradicts everything, we don't know why they should be able to reopen fact discovery to take this deposition, particularly because we don't know what they're going to get from it. We have the affidavit up here. I'm still looking at it from the screen share of Mr. Chaudhry, and I don't know what you're going to do other than trying to get him to recant the obvious. He's just saying he was never at any meeting. He has no knowledge of the meeting taking place, and he never personally witnessed anything. And this isn't our witness. We didn't bring him up. This is a witness they brought up in their interrogatories and they brought up in their own deposition. It seems like now that we're getting closer to our motion for summary judgment, they saw that their own fact witness is not saying anything that they think he's going to say. And now they're all looking to reopen discovery to take this deposition, even though they know fact discovery is closed.
So let me say what I generally do in this situation is if this is a brand new witness that no one knew about, obviously I would allow the deposition to go forward. But it sounds like, Mr. Chaudhry, you knew about this witness before fact discovery closed. Is that correct?
Yes, we did know about this witness, but we didn't know about this testimony, which they obtained after the close of fact discovery. They obtained this after the close of fact, a month after, and then they never served this to us. We never got this until they filed their October motion for summary judgment. So they went and got this. They went and got this evidence after the fact discovery, and then they're sandbagging us by holding it until October, and then they're using it as part of their motion for summary judgment. We should be able to take the deposition then.
Your Honor, if I may, I don't think that we have to give them any notice of this, that we got an affidavit from their own fact witness that they listed in their interrogatories. We were just doing our diligent fact discovery. And that's why, they say there's a witness. We go out and ask the witness. They told us he was there. I don't know why they didn't. I don't know why they're waiting till now. We did put in our motion for summary judgment because we think it directly contradicts what they're saying, in which they say they had this person witness it. He says he was never at a meeting and never witnessed anything. And this is what their fact witness, who they knew about before discovery closed. And we brought up a really good quote from the Texas Supreme Court about this exact same thing, which says the fact that movement did not have an opportunity to review the depositions of his own fact witness or depose the state's witness is a predicament of its own making. That is a risk the movement took by not diligently pursuing discovery. And that's what we feel like they're doing here, is they didn't feel like it was worth their time to depose this fact witness they knew all about. And they insisted that they close discovery on us. And we asked for a motion for continuance to discovery to continue fact discovery deadlines, and they didn't do it. And in their motion right now, they don't even give any evidence of good cause. I mean, if you look at their motion, it's completely bereft of any evidence that shows what's necessary for a good cause to reopen discovery. They don't tell us what they expect to learn from this deposition. Are they expecting him to recant everything they said? So they're not expecting to prove. They haven't shown that they've done any due diligence. Why? I'm not
really as concerned about that. I'm more concerned about the issue that they already knew about this witness before.
But they obtained this.
They did, Your Honor.
After the close of fact discovery.
But you knew about this fact witness before discovery closed. You could have taken his deposition or gotten an affidavit or whatever. I'm going to go ahead and deny the motion for leave. Mr. Rowling, if you could go ahead and send us a order on that. All right, guys.
Oh, I have one more thing, Your Honor.